I have nothing right here, so I cannot do anything right now with this sentence.
So what should I do from here, Your Honor?
Just, I guess, wait. And then once we get something from the Department of Corrections that's actually filed, I can look at that. But I believe I amended your bail so you can talk to your wife. So can't she find an attorney that can represent you? Well, I can't do anything until I have a filing from Department of Corrections. So, and I don't even know when, Lieutenant Mangan, if he is revoked, what is his release date? We will go on the record in the matter 26 CF 42 State of Wisconsin versus Scott Lang. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lang appears in person in custody in Burnett County Jail. We're set for a preliminary hearing. Mr. Lang, you do not qualify for a public defender, and I don't know if I have an application for a court appointed. Did you fill out an application for a court appointed attorney?
No, Your Honor, because I would like the opportunity to be able to vet an attorney, because I did have one at one time. But within a couple of days, he did the exact opposite that we talked about. So with my background, I have issues with people trying to railroad me, so I haven't had a chance being in jail for a firecracker to get out of jail to retain my own counsel, someone that I trust, and so I'm just seeking that opportunity. I will, if I can ever get out of jail over this firecracker, I can hire my own attorney.
I understand, and I'm hearing where you're coming from, and I understand you do have a right to not have a court-appointed attorney, and you can waive time limits, which you have done because you want to seek your own attorney. There comes a time where we have to have the matter moving, though. However, you are being revoked in your other matter, which is, I think it's just a misdemeanor, 24 CM 196. Is that the case? Yes, in that matter. And the court has not yet received any revocation packet or anything indicating that you are being revoked.
Well, that happened on the 22nd of last, it should have been processed by now.
Of what day?
Last month.
I don't have anything. And when you sent me a letter and you said, Judge, I'm requesting a sentence modification,
yes,
et cetera, and a bond modification. I had my assistant confirm, because I checked my file. I have nothing that says that you're being revoked. I only have that you're telling me you're being revoked. I have nothing from the Department of Corrections telling me you're being revoked.
Does the jail have anything yet? Do you know?
Judge,
they were going to check on it.
I believe Mr. Lang received a letter from the Department of Corrections stating the decision was made that he would be revoked, but I believe there's a time for appeals.
Yes, so that could be it. And you would have to talk to your agent if you wish to waive that appeal time. Right now, you're kind of in limbo.
I did tell Locker that I waived it because he was the one that encouraged me to write the letter. He said after the 14th, then it comes into effect. Well, I know that's only been 6 days, but.
Yeah, no, the last thing I have, I don't have that you're revoked at all. I just have the letters from you asking me to look at the sentence again. And then there was something filed on July 13th, which is just a Department of Corrections payment history or something, but nothing that says you're being revoked. Usually I get this like document that says defendant is being revoked and they're either being sent to court for sentencing or they're going to be sent to wherever, return to Dodge or return to Burnett County Jail or stay in jail until the sentence is served. I have nothing right here, so I cannot do anything right now with this sentence.
So what should I do from here, Your Honor?
Just, I guess, wait. And then once we get something from the Department of Corrections that's actually filed, I can look at that. But I believe I amended your bail so you can talk to your wife. So can't she find an attorney that can represent you?
Well, yes and no. I mean, she's not as learned and schooled as I am with this type of thing, you know, and so
And you're just saying because she hasn't been in the system like you have been in the system, not
exactly,
that she's not smart.
exactly,
Right, okay.
exactly. Yep. That's exactly what I'm saying. Can I talk to my parole officer and see if he can expedite paperwork to you? So maybe,
Well, I can't do anything until I have a filing from Department of Corrections. So, and I don't even know when, Lieutenant Mangan, if he is revoked, what is his release date? Do you know off the top of your head?
Judge, I didn't want to interrupt, but I believe his agent just sent that ROW over here within the last 10-15 minutes.
Well, I don't have it, and I wouldn't be making a decision based upon just getting it right now here today anyway. So what I can do is I can wait to see if I get that, I can then read your letters, because I'm gonna be honest, I read them, I skimmed them, but I knew you weren't revoked, so I didn't have to think about it
okay,
until I knew that I didn't have proof that you were revoked.
okay,
And so I would need a couple things. I would need to get that actual document filed in your electronic file. I would need to know what your release date would be. It needs it because I also need to know that you actually did waive your appeal time.
mhm,
And then I can hold a hearing on, I guess, all of this on your bond modification as well as your request for amending the sentence. But without all the information, I can't just willy-nilly just guess and make a decision. I do need to keep your other case moving, your preliminary hearing. But if you're continuing to waive time limits until this other case can be figured out, but it can't be too long, even if you are released.
right. Well, by the first week of September, I know I'll be released and I'll have an attorney. I'm just hoping to be released sooner than that, but
Because quite honestly, you're only on a $500 cash bail. That's not anything that is significant. And that can be heard at the same time as any other hearing. But what I can do is I can reschedule your preliminary hearing. The Thomas Schmidt case. Or Kevin Schmidt, not Thomas Schmidt. Okay, I can set it for work nights. So is it probably better to have a hearing in the morning or in the afternoon?
Either one's fine.
Nah, I know, but what's better on your
Probably morning.
system? 9 in the morning? 9 in the morning, September 11th. We'll schedule your prelim for that long out there. And then I will get a hearing for the other stuff. I'll schedule that before, but for your preliminary hearing for the CF matter, the felony matter. That work?
yeah. So if we get the paperwork from the parole and probation department, we can still maybe address the other two issues.
Correct. I just have to look and make sure that they're both BA Schmidt's cases. Unfortunately, I can't hear you until August 11th at 10. The first opportunity that we have, unless a trial comes off. Which may happen on August 6th. But that's an ADA week. But right now I can schedule it for August 8th. Excuse me, sorry, August 11th. At 10. I'll get the documents. I'll review your letters as soon as I get the documents from DOC. The state would be able to make any argument with it because you're asking to amend sentence. And they'd be able to make argument as it relates to any bond modification on the CF matter, on the felony matter, okay? If any time comes off before then, we can move it up, but right now this is all I have.
Okay,
So work on that, but in the meantime, do you have the ability to research any attorneys?
Yeah. I mean, we have been, not a whole lot of luck right at this point in time, but
And some of the attorneys that you may be looking at or researching are attorneys that would possibly or could possibly take a court-appointed case, which is benefit to you. It's lesser money to them, but they do it for other reasons.
yeah,
So that may work as well. That's something to think about. We have some really good attorneys that practice in this court
Yeah.
that do that all the time.
well, I might put the application in and see what happens. See if it's somebody that I feel I can trust.
You could do that and we can go that route. And then you can see, I don't know if you've heard of Daniel Chapman, I could appoint him. Renee Landgraf, she's great, I could appoint her. Nicholas White, there are some really good attorneys that agree to take court-appointed cases.
Yeah,
So that's a route, but I'm gonna need to know if that's what that you're looking at doing. I need to know sooner rather than later so we can get someone on the case and you can start talking to them.
right. I can also send you some more information, another letter if I figure something out within maybe this week.
It would take money down though.
Yeah.
So, but not the 5,000, 10,000, 20,000 that some criminal attorneys
Yeah.
require for a retainer.
Yep.
So think about it, but August 11th, that's the date at least we have set right now. As soon as I get things filed, I'll take a look at it. And then if the trial comes off, we can put it in sooner. Okay?
Okay.
All right, so we're not going to proceed with the preliminary hearing today. We have the other date. Anything else from the state?
No, Your Honor.
Anything else, Mr. Lang?
No, Your Honor.
All right, then we're adjourned. Thank you. Is Cody? Yes, okay. Is Cody making appearance here today?
You gave her permission to appear, but I believe from the
I did. Is she gonna be with House Calls Them Nami?
No, they will be in a different Zoom.
Okay. Because I don't have her yet, but doesn't mean that I won't. And quite honestly, we don't necessarily need her with your filing,
Yes.
but we can wait another minute or so.
Okay, perfect. And if not, then.
Mr. Mulroy in custody?
I don't believe so, Your Honor.
We will go on the record in the matter 26 CF 56, State of Wisconsin versus Cody Capistrant. The state appears through Assistant District Attorney Jose Vila in person. We have Amber Sherwood, Defense Counsel in person. We do not have Ms. Capistrant due to matters arising off the record and other things involving Ms. Capistrant, her counsel, the state and corporation counsel. The court is waiving her appearance for today's purposes. The court did also receive a letter from counsel Sherwood raising competency. Therefore, the court is going to order a competency evaluation. And hopefully we can get that done as quickly as we practically can. I do believe we have another hearing in August.
August 3rd, Your Honor.
And what time, if you recall?
Yes, one moment. It is August 3rd at 9 a.m.
Let me go to August 3rd. All right, so August 3rd at 9 a.m. What I'm going to do is I'm actually going to set the criminal matter at 9 a.m. And for your knowledge and information, we're gonna just push that other hearing down to 9:15.
Okay.
I can't call them together.
Right.
So we'll just have to have the criminal one here first, because we don't know how long the other one's gonna be. And then we'll proceed and go down to have that other hearing, okay?
Perfect. And we still start at the 9 a.m.
Yes,
Okay.
yes. Oh, well, yeah, we may be able to get the report by, no, we won't get the report by then. Just a status, just put a status. Sometimes we're getting the reports lickety split, but sometimes it takes a little bit longer.
I was hoping because she's currently in Amory in a facility that maybe it could help facilitate. We'll see.
I really hope so as well, but we'll see. So August 3rd, status at 9, then we'll move on to the confidential matter. All right, anything from the state?
No, Your Honor.
Anything else?
No, Your Honor.
All right, then we are adjourned. Thank you.
Thank you.
Ms. Sherwood, I do need to speak with you momentarily in the back.
Yes, Your Honor.
How you liking being the bailiff? All right, so far. Good.
Keep trying to make him cry.
I'm sure this is a better encounter than some of the previous issues we've had since you two were in the same room together on that side.
Oh,
Yeah.
that's right. That's right.
EMS had to be called.
Some lady started puking.
Yeah.
Right there. Well, her blood sugar is, she absolutely should have been to the hospital. That was
Yeah.
not good.
I felt bad, but I was like, oh, I can get my work done while this is happening.
I was just,
All rise.
No, I understand. All right, thank you. You may be seated. Are we good? Should we just call it?
Your Honor, let's go on the record.
We will go on the record in the matter 26 CF 60, State of Wisconsin versus Timothy Mulroy. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel in person. We do not have Mr. Mulroy. We're set today in this matter for preliminary hearing. Mr. Mulroy doesn't appear. This matter was scheduled on June 10th at his initial appearance. He was in court and provided the actual and oral notice of today's date and time. The weather is good, but I can't recall off the top of my head. I don't believe he has a driver's license. So what is the state requesting?
I would ask for a warrant, Your Honor.
Mr. Feliski, stand mute or make any argument?
Your Honor, I stand mute.
All right, the court will issue a warrant, $250 cash, only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned. All right, thank you.
Thanks. Have a good day, Your Honor.
Thank you, you too. I guess we're just gonna wait for Mr. Corbijn and then we're gonna be ready to go. I'm gonna send the court into the wait. We will go on the record in the matter 26 CF 86, 26 TR 427, State of Wisconsin versus Maurice Corbijn. The state appears through Assistant District Attorney Jose Vila in person. Mr. Corbijn appears in person with his counsel, Emma Hanu, by video conferencing. We're set here today in this matter for a preliminary hearing. However, Mr. Corbijn, you're going to be waiving that hearing. Is that correct?
Yes, Your Honor.
I have in front of me a waiver of right to preliminary hearing document. Did your attorney go over that with you?
Yes, Your Honor.
Did she go over it thoroughly with you?
Yes.
Do you
Yes, Your-
understand it completely?
Yes, Your Honor.
Is that your signature on the bottom of the page?
Yes, Your Honor.
Do you understand that once you give up the right, it's forever and you can't get it back?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
I'll find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Ms. Hanu, did you thoroughly go over that document with Mr. Corbijn?
Your Honor, over the phone, I verbally went over what the document contains, and then I had my colleague, attorney Amber Sherwood, go down to the jail and go through it again in person with Mr. Corbijn. So I am confident that he understands what a preliminary hearing is and that he would be waiving it knowingly, voluntarily, and intelligently.
Thank you, Ms. Hanu. Information?
Thank you, Your Honor. It has been filed and it mirrors the criminal complaint.
It mirrors the criminal complaint. Does he wish to move forward with his arraignment right now?
Your Honor, we would enter a not guilty but ask for 10 days to be preserved on pre-arraignment rights.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. 10 days granted. I have a motion to modify bond argument, Ms. Hanu.
Thank you, Your Honor. The court originally imposed a $5,000 cash bond in this. On June 28th, Mr. Corbijn, pro se, sent a motion to the court requesting it be lowered to $3,000. Following my appointment, the court requested that I file a formal motion. I filed a formal motion requesting an amendment from the cash bond from $5,000 to $3,000. Since following that, although not in there, but relevant for the court, Mr. Corbijn has informed me that upon his release, he intends to find AODA counseling and treatment. It just has not been finalized yet. I believe this is still a significant amount of cash that would ensure his appearance.
Mr. Vila?
The state has reviewed the motion filed by the defendant prior to getting counsel and by Ms. Hanu. Given that this was originally referred as a higher level OWI and he was actually charged out as an OWI 5 or 6, the state has no objections to reducing the cash to $3,000, same conditions.
All right, the court will amend the cash portion of the bail bond to $3,000, same conditions. All right,
Yes, yes, Your Honor.
we need a return date. First at 1.
Your Honor, I am in a trial that day.
September 1st at 1.
That would work for me.
Right, September 1st at 1. All right. We will see you then.
Thank you, Your
We
Honor.
are
Have a good
adjourned.
day.
You too. Miss Ingstrand? Did you apply for a public defender?
Last time I kind of misunderstood.
Oh, yeah, and there was an offer, I believe it was to
Yeah.
amend to simple possession for costs.
Correct, Your Honor.
Can I do that without a public defender?
Yeah, you
Yeah.
can, yeah, if that's what
See,
you
I
want
was,
to do.
there was too much going on at one time that I misunderstood.
If that is the case, may I release my witness?
You are released.
Thank you.
Thank you.
Sorry.
That's
We
fine.
will go on the record in the matter 26 CF 48, 26 TR 297, State of Wisconsin versus Michelle Ingstrand. The state appears through Assistant District Attorney Jose Vila in person. We do have Ms. Ingstrand appearing in person without counsel. We were set today in this matter for a preliminary hearing. However, Ms. Ingstrand, you have thought about the state's offer of plead to an amended count of simple possession THC for costs only, and you wish to accept that. Is that correct?
Yes.
All right. Formal motion to amend count 1 down to a misdemeanor THC.
So made.
Ms. Ingstrand, do you understand that you have the right to an attorney? And that means that you would have the right to have an attorney who goes to law school to look at cases, to look at facts, to look at if there are any defenses or a lack of defenses, to negotiate with the state, to argue to the court and to a jury. Do you understand there's certain advantages to having a lawyer?
Yes.
And so there would be, the same is true opposite of those advantages, which would be disadvantages. Do you understand that?
Yeah.
And you wish to represent yourself?
Yes, please.
How old are you?
40.
Can you read, write? You understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Do you understand that you would be pleading guilty to a misdemeanor possession of THC with a recommendation of costs only from the state?
Yes.
Do you understand that you would have the right to a trial? You would have the right to have an attorney or yourself cross-examine the state's witnesses or call witnesses to testify for you. You would be able to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights you're giving up?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around April 17, 2026, you possessed a substance. The substance was a controlled substance, THC, and you knew or believed that substance was a controlled substance, THC. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or up to 6 months in the county jail or both?
Yes.
Do you also understand that there is a recommendation for costs only, but I'm not bound to follow that, meaning I could sentence you to the maximum penalty if I thought it was warranted?
Yes.
Are you admitting here today you in fact did possess THC
Yes.
and you knew it was THC?
Yes.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes.
And voluntarily?
Yes.
You have any, so you have no questions and you're just ready to proceed and enter a plea?
Yeah.
As to count 1, amended possession of THC simple, a misdemeanor, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of misdemeanor THC. A judgment of conviction will be entered. The other TR matter will be dismissed and read in as well. Mr. Vila, argument, please.
Thank you, Your Honor. I believe cost is an appropriate disposition here. Ms. Engstrand came and she's wrapping this case up in an efficient manner. And given the fact that this is a THC level offense, I believe costs are more than appropriate as a sufficient deterrent for the future. Thank you.
Thank you. Ms. Engstrand, anything you want to say or you want to let me know?
No, thank you.
Okay, this is not a very serious matter. It's possession of THC. However, it's still illegal in Wisconsin. I don't see when it's going to be legal. If you want to do it, great, grand, wonderful, but just go to any state that it's permitted and authorized and legal. Any state around Wisconsin, just not in Wisconsin. I believe you have some cash bond posted. Oh, sorry, I was looking at the wrong case.
Mhm.
Sorry, I was looking at a different case. I had that pulled up. You do not have any cash bond posted. Are you still in Lindbergh Circle?
Mailing, well, my kids live there.
Okay, so are you just you just go from place to place right now?
My mailing address is here.
Your what
My
address?
mailing address is the house
Where would you like us to send mail?
to the public health to what do you call it? Down the hallway, the opposite side.
Clerk of Courts?
Yes, please. No, not the clerk of courts.
Department of Health and
Human
Human
Resources.
Services?
Yeah. They take my mail.
You take your mail?
Yep, and I come here and get it.
Okay, well, I don't know if we can do that.
It is under there. It is under there as my mailing address, and then you should have it on file. That and the house that I stay at. on
I just
Highway
have
70.
Lindbergh Circle, but, well, does your telephone number end in 9103?
Nope.
Can I get an updated, please?
Well, 715-475-8596.
Okay, that's important that we at least have that. May we send you text messages if we need to?
Yes.
Okay, now here's what I'm gonna do. It's very important that you make sure you make your payments. I'm only gonna assess $250. I'm waiving the rest of the court costs and fees. I don't think you are rolling in the dough, and I think that you're accepting the responsibility and you're being accountable and you're taking care of it very quickly. So that's why I'm waiving all other costs and fees. Are you currently working at all?
No.
So what I'm gonna order is, and this is, again, very important that you hear this and very important that you do this. I will allow you to make $25 a month payments, but if you don't do that, a warrant will be issued. You could sit up to 6 months in jail. 25 is the lowest I can go. And your first one's not gonna be due until the end of August, so hopefully you can figure it out. The sooner you pay that off, the sooner you get me off your back, okay? Because the court can enter that civil judgment against you and a warrant, so it's very important that you do that. Otherwise, I will waive the remaining costs and fees, because again, you're stepping up. So you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. When you're done here, you'll just go to the jail outside of the building, all the way around the back to the day reporting for the jail, provide your DNA. You have the right to request it be expunged through a written letter to the Department of Justice, not to the court, but to the Department of Justice, okay? I believe that covers everything. Mr. Vila.
I would agree, Your Honor.
Ms. Ingstrand, anything else you want to say?
No, thank you.
Okay, thank you. We will go on the record in the matter 26 CM 84, State of Wisconsin versus Shanna Corbine. The state appears through Assistant District Attorney Jose Vila in person. We have Daniel Chapman, Defense Counsel, in person with Ms. Corbine. We're set today for a status conference. Mr. Chapman, can you update the court?
Your Honor, I was just appointed, I believe, on the 6th. I do have an offer, but I don't have discovery yet, and I believe that the matter will be resolved. I just need to actually look at the evidence.
Okay, all right. Holy guacamole, man. I can do September 28th, 10:30.
That works for me.
All right, you can come get your notice and you're free to leave. We're off the record. When are you gonna be able to make that deposit?
Pretty soon, pretty soon,
What does pretty soon mean?
this next payday, I will for sure,
Okay,
something.
and when's your next payday?
I haven't gotten. it
When,
yet, but if we
well, I
don't
get paid
one,
on Wednesday,
it's gonna be
next
an
Friday,
honesty.
2 Fridays. Or wait, not this coming up one, but the next one,
So on the 31st?
yes,
Okay, make sure that you have it paid then by the 4th of August,
okay,
all right?
thank you.
Yes, September 28th at 10:30. You can just come on up and Mr. Eads.
Yep, have a good day.
Thank you. Okay, just give me 1 second. We will go on the record in the matters 25 CF 127, 25 TR 780, 837, and 838, State of Wisconsin versus Michael Eads. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Eads in person with counsel Daniel Chapman. We're set today for status conferences. We do have a plea and sentencing scheduled for October 1st. Are we still on track for that, Mr. Chapman?
We are, Your Honor. Mr. Eads is still in treatment following the conditions of his bond, and we are still on track for a plea on August 1st or October 1st.
All right. And I can't recall, was there an agreement to a collateral attack, or were you not able to find one?
No, Judge, there is no collateral attack issue.
Would it be OWI 5 or
Yes.
6? Okay, all right. So then we will see you on October 1st. You can come up here and get your notice and you're free to leave. Thank you.
I believe those are my only two 1 o'clock matters, right, Judge?
I have Mr. Morales. I may have appointed him to you. Yes, I've appointed him to you.
Yes, I have
Amy?
him. I just didn't realize he was at 1 o'clock.
Yes, he is right there. If you need to speak with him, you sure may.
Have I been appointed on his new matter, Judge?
You have been appointed, well,
I've been
on
appointed on-
26 CM 32.
Right. Come on up, Mr. Morales.
And then he has a CT 35, which the court will appoint you on that as well.
Give me a call if you need anything, okay?
We will go on the record in the matters 26 CM 32, 26 CT 35, 26 TR 04, and 19. State of Wisconsin versus Antonio Morales. The state appears through Assistant District Attorney Jose Vila in person. Mr. Morales appears in person with counsel Daniel Chapman. We're set today in these matters for initial appearances. We do have the newly filed 26 CT 35, which is another OWI second allegation. Mr. Chapman, do you need a copy of that criminal complaint?
I have not seen it yet, so yes, I would appreciate it. I have discussed it with Mr. Morales.
You can come up here and get a copy.
Okay.
Mr. Morales, you are currently behind on your payments, about $300. When are you going to be able to catch up?
I did not know anything about that. I can pay it as soon as possible. I just got done paying $385 today for setting up this intoxicated driver intervention program. But I believe I should be able to pay the $300 by probably next week.
All right.
hoping. If not next week, for sure the week after.
I can give you until August 4th to get all caught up.
Okay, that'll work for me.
Okay,
And you said it's just 300 that I owe?
100.
Okay.
yes. All right, were you able to go over that criminal complaint with Mr. Morales?
I just read it myself, Judge. A quick skim shows no conflicts that I can see. I did discuss earlier with Mr. Morales the fact that he was charged with another OWI and specifically what the possible penalties would be if one became a third offense. He understands what he's accused of and what the penalties are.
All right, so not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. We need a status date. September 28th at 10:30, September 28th at 10:30.
Yes, Judge.
I'm going to presume you're going to discuss and look at this once you get discovery here and try and see if you can get some type of global, if that's possible.
Yes, Judge.
He's already doing the IDIP, so we'll just get a status on that then. You can come up, get your notice, and you're free to go.
Thank you, Your Honor.
Okay.
Don't forget that August 4th date, okay?
Okay, I won't.
Now I am going to go speak to Ms. Buell. Charge of possession of amphetamine. The other two charges will be dismissed or dismissed and read in either way. And there will be a joint recommendation for costs only. She is already on probation and she is in drug court.
All right, in Washburn County? Yes. Okay. So I do have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
And is that the agreement that you've reached?
Yes.
Mr. Vila, formal motion to amend to a possession of amphetamine
So made.
granted. Did your attorney thoroughly go over this document that is essentially word for word?
Yes.
Is that your signature on the second page?
Yes.
You're pleading guilty to 1 count of possession of amphetamine. You're 43, you have 12 years of schooling, you can read, write, you understand the English language. No treatment for a mental illness or disorder except for AODA, correct?
Correct.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did he go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on the first page. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
I'm a citizen.
I have to ask that to everybody. Do you understand that the state would have to prove on or around April 20th, 2026 in Burnett County, Wisconsin, you possessed a substance, the substance was a controlled substance in an amphetamine classification, and you knew or believed that substance was a controlled substance in an amphetamine classification? Do you understand what the state would have to prove? Do you understand the maximum possible penalty could be a fine of up to $5,000 or up to 1 year of incarceration or both?
Yes.
Do you understand that there is an agreement here for costs only, but do you understand I'm not bound to follow that?
Yes.
That means I could sentence you to that maximum penalty if I thought it was warranted.
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did your attorney go over with you the criminal complaint and those facts that allege those crimes that were committed?
Yes.
For the most part, are those facts accurate?
Yes.
Admitting here today, you in fact did possess an illegally controlled substance?
Yes.
And it was in an amphetamine classification?
Yes.
And you knew that?
Yes.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Ms. Buell, for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes.
And voluntarily?
Yes.
Has your attorney represented you competently? Has he answered all your questions?
Yes.
You're satisfied with the services?
Yes.
Any questions for the court or your attorney before I proceed?
No.
As to amended count 1, possession of amphetamine, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count 1. Counts 2 and 3 will be dismissed for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. Ms. Buell is here taking responsibility for her actions. The nexus of this case is that this was really a personal substance abuse issue. She was cooperative with law enforcement on the scene regarding that personal substance abuse issue. And as Attorney Chapman already noted, she's going to be on probation out of Polk County for at least the next 2 years. Similar situation for personal substance use issues. As such, I think, given the fact that she's going to be on supervision for another 2 years, time cost is most that are appropriate here, and the needs to protect the community are more than satisfied. I would ask the court to adopt. Thank you.
Thank you. Mr. Chapman.
I would just add that the obstruction behavior in this case was mostly directed by the driver of the vehicle. And in fact, Ms. Buell tells me that every time the police officers left the vehicle, she was telling him, no, you need to get out. They're going to break my window. He was just refusing and she was just sitting there quietly. Also, she spent about 2 weeks in jail after this due to a probation hold.
All right, thank you. Anything you want to add or you want to state to the court, Ms. Buell?
No.
Are you currently employed?
Yes.
Where do you work?
I work at the Prime Barn.
Oh, that's good. Okay. So you are employed and do you work part-time, full-time,
It's kind of, I guess, full-time.
$12 in tips?
Yeah.
Okay. Um,
Well, actually, I make $6.
Oh. oh, because you're bartending.
No, I don't bartend. I'm just a waitress and I.
Waitresses only make $6.
Yeah.
I could have
Yeah.
swore I just had a case where somebody worked at the Prime, she made $12 plus tips.
Maybe if she was a dishwasher or a hostess.
I swear she
when
said she was
waitress-
a bartender and or waitress.
Oh, yeah, I make $6 as a waitress or $12 as a dishwasher.
Okay, all right. Well, either way, you make some money. This isn't that serious. It's a use case. Sounds like you're in treatment court and you're gonna be on probation for 2 years. I'm willing to waive some costs and fees here and only do the DNA surcharge, but I'm gonna tell you, and I'm gonna tell you right now, if you don't pay this off and you don't pay your monthly payments, I will issue a warrant and you will sit more time for failing to pay, okay?
Okay.
So I will only assess the DNA surcharge of $200 because quite honestly, you're taking care of this very quickly and you should, I'm gonna give you a benefit for that and I want you to succeed. And so I'm gonna waive the $243, but only assess the DNA surcharge of $200. I'm going to order that you make payments at $50 a month. First payment due in August. So by the very last day of August is your first payment due. But again, if you fail to pay, not only will I enter a civil judgment against you, I will issue a warrant and you could sit up to 6 months in jail. I watch fees and payments like a hawk. Okay, so make sure you pay that because that is part of your sentencing. And that's exactly what this is. And I'm giving you a benefit of waiving some of that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm going to order 10 days of jail time served. You sat it. I don't care if you get credit on your other case or this case. Either way, you have some credit. And then that DNA surcharge. I do need to order your DNA. You need to leave here today. When you're out of the courtroom, you go out of the building all the way to the back to the jail day reporting, provide your DNA. You would have the ability to request it be expunged through a written letter to the Department of Justice, not to me or this court, but to the Wisconsin Department of Justice. It's easy to do. You can Google it or ask Mr. Chapman and he can help you. So 10 days jail, time served, $200 DNA surcharge, waive rest of costs. I think that's all. Mr. Vila,
I would agree, Your Honor.
Mr. Chapman.
Nothing else, Your Honor.
All right. Good luck to you, Ms. Haley. Down and slide back, down and slide back.
At least I'm not the only one.
We will go on the record in the matter 26 CF 52, State of Wisconsin versus Brandon Bearhart. The state appears through Assistant District Attorney Jose Vila in person. Mr. Bearhart appears in person with counsel Daniel Chapman. We're set today in this matter for a status conference. Mr. Chapman, please update the court.
Your Honor, I have discovery and I have an offer. The offer will involve Mr. Bearhart doing an assessment and follow through with treatment. He is actually already engaged to go to Coinga, if I'm pronouncing that correctly, for 60 days of inpatient. When we come back, we can do a plea and sentencing.
Okay. Is it plea and then costs?
Yes. Plea to a misdemeanor and costs.
This is a Mr. Schmidt case, if that helps for scheduling.
Thank you. I could do October 5th at 1:45.
You'll be done by then, right? I have to be in Hudson that afternoon.
What about at 9?
That would be fine.
October 5th at 9. All right, you can come get your notice and you're free to go. Thank you.
Assuming everything goes according to plan on being there about 15 minutes early and we'll have some paperwork to go through. Thank you.
Mr. Lowry? We will go on the record in the matter 26 CT18, State of Wisconsin versus Jonathan Lowry. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lowry appears in person with counsel Daniel Chapman. We're set for a status conference. Mr. Chapman, please update the court.
Your Honor, the state is trying to track down some additional body camera footage for me so I can decide whether or not there's a viable motion to suppress evidence.
Okay. How long do you think it's going to take to get that, Mr. Vila?
It's Mr. Schmidt's case.
All right.
I think if you gave me a status date on the September 28th date, I would know well before then whether they're going to find it or not and what that means for Mr. Lowry's case.
I cannot do it on the 28th because that's an ADA week, but I could do September 24th at 9:15.
That would be just fine.
September 24th at 9:15.
That work for you? Okay.
All right, we will see you then. And come get your notice and you're free to go. Mr. Roy.
Sure.
We will go on the record in the matters 26 CF 80, 26 CM 53, 26 CM 72, 26 TR 05 and 06, 26 TR 153, 26 TR 365, and 366, and 367, and 368, and 369. State of Wisconsin, County of Burnett versus Tevin Roy. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Roy in person with counsel Daniel Chapman. We're set here today in these matters for status conferences. Mr. Chapman, can you please, and initial appearances, I guess, in the 26 CF 80, 26 CM 53 and 72 cases. Mr. Chapman, were you able to go over the criminal complaints in those cases with Mr. Roy?
On the felony matter, yes. I did not realize I had been appointed on 2 misdemeanors as well, so I did not review those with him, but
I can print those out. One
Thank you.
is battery,
have you seen those? Okay.
and the other is operating without a valid license, second within 3 years, possession of THC and paraphernalia.
Yes, if I can just review those quickly, I'm prepared to go forward.
There you are.
Making sure. Is this from the same incident as the OWI? No, this, January 1st.
You understand, or are you ready?
No, different days. Well, it's 30 days. Penalty on that is 6 months. Penalty on that is 9 months. We'll take care of them all. It's just gonna plead not guilty today. Yes, Judge, we're ready to go forward.
He understands all charges in those 3 cases and the maximum penalties.
He does, Your Honor.
Does he waive formal reading?
We will waive reading on each of the 3 complaints and enter not guilty pleas to the misdemeanors.
Not guilty pleas will be entered on his behalf to the misdemeanors. With the felony, he's entitled to a preliminary hearing. Is he waiving time limits?
Actually, Judge, he's prepared to waive the preliminary hearing outright today.
All right. So, Mr. Roy, do you understand what it is to have a preliminary hearing?
Yeah.
The burden is on the state to prove a felony was probably committed and probably committed by you. Do you understand that? Is that a yes?
You gotta say yes.
Do you understand that by waiving your right to a preliminary hearing, you are agreeing that the state can at least meet that burden?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, would be able to call witnesses to testify for you. He'd be able to discover things about your case, which could include some defenses, and he could produce evidence on your behalf. But do you understand for today's purposes, you are giving up those rights?
Yes.
Do you understand that if the state does not meet its burden as to those felonies, I could amend them to misdemeanors or dismiss them altogether, but you're giving up those rights?
Yes.
Do you understand that as a result of waiving your right to a preliminary hearing, that these matters will be bound over to future proceedings, which could include a trial?
Yes.
Do you understand that once you give up your right, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
I will find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Vila?
I'm going through and attempting to file it. I'm having a technological issue on my end, so it will be filed after this hearing, Your Honor. But it will likely mirror the criminal complaint.
Will mirror the criminal
It
complaint.
will likely or it will.
Yeah.
It will mirror the criminal complaint. My apologies.
All right, proceed with an arraignment
plead
today
not
or set
guilty
it
to
for
these as
another
well.
date.
Given that the charges will mirror the criminal complaint, Mr. Roy is aware of those charges. We can go forward today.
All right, he understands those charges and maximum penalties.
Yes, he does.
Waives
And
formal reading.
he will waive reading and plead not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Let's schedule you for your September 24th at 9:15.
Thank you. And can all the traffic matters tag along?
They sure can. September 24th, 9:15. We'll see you then. Come and get your notice and you are free to leave.
I believe that was my last one.
I believe it is too.
Thank you.
Thank you.
Questions, Mr. Roy? Okay, give me a call if you do.
You want this microphone on?
I'm sure that is probably better. I don't know how they got off. Unless their power went out. Do I have the jail or is this just kind of waiting? And I have Miss Pulaski here. This would be, there's an allegation of threat to cause bodily harm to certain individuals involved in the court or legal system. Would be in victims' rights compliance.
As far as I'm aware, there is no victim that's coming forward today.
All right, Ms. Pulaski, you can come on up here. We will go on the record in the matters 26 CF 66, 26 CT 10, State of Wisconsin versus Regina Pulaski. The state appears through Assistant District Attorney Jose Vila in person. Ms. Pulaski appears in person without counsel. Warrants are quashed. Ms. Pulaski, you have felony allegations in the new case and you're here for an initial appearance. Were you going to apply for a public defender?
I didn't know if I'd still qualify because I didn't before. But I don't have the same job, so yeah, I was.
Well, yeah, so you don't have a job?
I do have a job, but I don't have the same one. I was making way more money at the casino.
Okay, so maybe you may be able to qualify, but you're not entirely sure. So let's do this.
And I was talking to a guy from at the 10th hole, but he practices in Minnesota and he was gonna give me a number to one of his people that he talks to in Wisconsin. Like a friend of his, lawyer.
Okay, an attorney? Either I can move it to this Wednesday at 1, or I can't hear it until,
I could go forward right now.
well, because then the time limits start to run with the prelim. So I'm okay if you want to move it to August 12th or this Wednesday.
I mean, this Wednesday's kind of close. I gotta
I'm just
pay a-
saying because the public defenders will be here.
Okay,
And so then I know that you can meet with them and
Okay.
apply.
I can do that
So
then.
you can do it this Wednesday?
Yeah.
All right, so let's just move it to Wednesday at 1.
One.
So be here and then you'll be able to speak with the public defender and see if you qualify. You can still talk to that friend, 10th hole
Right.
friend, lawyer friend, even if you have a public defender, but then we know we can get it moving so you don't have to be in this standstill. Now, you were working on getting your license.
Oh, yeah, but then I had a hiccup and had to pay extra money to get out and then I had a warrant and I had to pay that money and
So your hiccup is you need to pay money to get your
Yeah.
license? What else do you have to do other than?
I
pay
still
money?
gotta do the Mad Impact panel.
Okay, your impact panel.
Yeah.
You call Aurora just to make sure that you're still on the good to go to do that,
Okay,
because you only have so long to fit it in,
okay,
because you don't want to have to start all over again. So I
Right.
would call Aurora today, okay?
Okay.
And just find that information out and do the impact panel if you still have that time to do it. Because then at least you're working towards getting your license and that's one
Right.
thing off your list, okay?
yep,
So we'll see you here this Wednesday at 1. Come get your notice and you're free to go.
thank you.
Mr. Mosier? We will go on the record in the matter 26 CT 11, State of Wisconsin versus Guy Mosier. The state appears through Assistant District Attorney Jose Vila in person. Mr. Mosier appears in person without counsel. We're set for a status conference. Mr. Mosier, where are you in the process of getting your license?
I'm no closer than I was last time because I can't get a thing made up with Douglas County for my child support. All I owe is arrears, but she doesn't want,
Have a payment plan?
she'll set up a payment plan, but she won't give me a thing for my license right away. She said it'd probably be about 6 months. I probably have to make like 6 months.
Okay, so I think the offer is then to plead to the charge for costs or trial.
Oh, I don't want no trial. Can I plead to no valid driver's license?
You don't negotiate with me. I'm not involved in any of those things. That would be with that gentleman right there. If you need
And we'll
some
settle
time.
it, we'll settle it today.
It's an OAR. It's for cost only.
And then what else? Well, what comes with the OAR?
Well, what he's saying is plead to the misdemeanor operating while revoked for costs only. So it wouldn't be jail or anything, wouldn't be the recommendation to the court.
Okay, and then how long does that make me for my driver's license again?
That's a question for the Department of Motor Vehicles.
Oh, okay. So probably like 6 months I'll be,
Probably.
okay, well then that would probably put me close to I can have my driver's license again because then I'll be on Social Security.
Okay, that would be good. So hopefully don't drive before then. So do
Nope,
you wish to accept the state's offer?
yes.
Do you understand that an attorney goes to law school to learn how to negotiate and to look for defenses and to argue and present evidence?
Yes,
Do you understand that not having a lawyer means that you'll have disadvantages?
yes,
Do you wish to represent yourself here today?
yes.
How old are you?
61.
Can you read, write? You understand the English language?
Yes,
Any drugs, alcohol, or other medications in your system?
nope,
Do you understand that you would be able to go and have a trial? You'd be able to have an attorney or yourself cross-examine the state's witnesses or call witnesses to testify for you. You'd be able to testify on your own behalf or remain silent and not have your silence used against you. You'd also be able to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you'd also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights you're giving up here today?
yes, Your Honor.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes,
Do you understand that the state would have to prove on or around January 29th, 2026, that in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway or roadway of this county and state during that revocation period or thereafter, and the revocation was a result of an OWI or similar offense?
yes, Your Honor.
You understand the maximum possible penalty could be a fine of up to $2,500 or 1 year in the county jail or both?
Yes, Your Honor.
Do you understand that the agreement here is a recommendation to the court for costs only? But do you understand I'm not bound to follow that?
Yes, Your Honor.
I could sentence you to the maximum possible penalty today if I thought it was warranted.
Yes,
Are you admitting here today you in fact did operate a motor vehicle while revoked
yes, Your Honor.
and you knew it was revoked?
Yes,
Has anyone made any threats or any promises to you for you to plead guilty today?
no, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes,
and voluntarily?
yes,
Do you have any questions for Mr. Vila or for the court?
no, Your Honor.
As to count one, operating while revoked, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of operating motor vehicle while revoked. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. Mr. Mosier is here accepting responsibility for his actions today. Looking at the timeline for this case, it's a pretty quick turnaround for as far as OARs go. And given the level of offense that we're dealing with, I think costs are more than appropriate here, and the additional license penalty that will be assessed are more than appropriate to protect the needs of the public. I would ask the court to follow. Thank you.
Thank you. Mr. Mosier, anything you want to add or you want to let the court know?
No, I'm just gonna work on getting my job.
I really want you to get your driver's license.
I really
Mr.
want him
Mosier.
to.
It's not very fun to see you here.
I know, I like you, but I don't like to come here to see you.
Same here. I prefer you not. Yes. So I think costs are appropriate. What the court is going to do is you're pleading guilty, accepting responsibility pretty early on. So I'm just going to assess $250. That's the DNA surcharge with a slight bit of a fee attached because we have to pay for this somehow. I'll waive the rest. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need you to go to the jail and provide your DNA.
I think they have that.
You still have to go every single time to give your DNA, or I have to order it. And they just have to make sure that they have it. But it also says I need fingerprints anyway. With every single case, I have to get fingerprints. So go ask, you'll get the paperwork, go say, I need to give fingerprints, my DNA. You have the right to request your DNA be expunged through a written letter to the Department of Justice, not to the court, to the Wisconsin Department of Justice. You can Google it. It's easy to do. Again, 20 days to appeal. Am I missing anything?
No, Your Honor.
Mr. Mosier?
Nope.
Come get your documentation, fingerprints, DNA, you're free to go. You go outside, walk all the way around to the back of the building. It's called the day reporting for the jail day reporting. Thank you. Do you say Mackie or Makey?
It's Mackie.
Mackie, okay.
Finlander, I guess it was Mackinnon when my grandma came right off the boat from Finland and they shortened it to Mackie. Anyways.
Well, it's
That's
good.
the history of the name.
We will go on the record in the matter 26 CF 102, State of Wisconsin versus David Mackey. The state was through Assistant District Attorney Jose Vila. Mr. Mackey appears by video conferencing in custody in Burnett County Jail. We're set today for a waiver of extradition hearing. Mr. Mackey, do you understand you have the right to say, you know what, Judge, I want an attorney and I want the state of Minnesota to prove to me that they actually have jurisdiction over me. Do you understand you have the right to do that?
I do.
And I do have in front of me the signed waiver of extradition affidavit. Did you sign this affidavit?
I signed that knowingly and voluntarily.
All right, so you wish to be voluntarily extradited to the state of Minnesota?
Yes, I do. And I
Has anyone
understand.
made any threats or any promises to you for you to waive your right to a formal extradition hearing?
No threats, no, nothing like that, no.
So
I
you're doing so
voluntarily,
freely and intelligently.
absolutely.
All right, and signing these documents, you will be extradited shortly whenever Minnesota decides to come pick you up, okay?
Okay, any idea on how long? I suppose you can't really say, but it's usually within a week, I think. But I did, based on the last time, I gotta quit making bad choices. Every time I lose my housing, I end up coming down here, and hence the parole violation. And I didn't. All I had to do was text my parole officer. It was just stupid on my part. All I had to do
I
was
would agree
text to
with that.
check in. I don't understand why. Anyways, I'm just.
So it's going to be who can provide enough proof for the court to determine who owns the dog. I'm gonna have both parties please stand up, raise your right hand, and you will be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you may be seated. Ms. Cleveland, you have filed the complaint seeking the return of the dog. And you said that you got the dog from your son, August 24th, 2026.
Yep.
And that it is your dog. Mr. Hunter says that it was a wee dog. And so he is asking to have the dog. Both of you are here without an attorney, so you're going to be able to provide your testimony to the court in what's called a narrative, like a story. And then the other person will be able to ask you questions based upon your story to the court. I will be able to ask you questions as well. You may begin.
I got the dog from my son, Ryan. He's here in court. He's my witness. And on June 13th, I was moving back to my mom's because I was going back and forth to Ted's and my mom's. And he took off with my dog and wouldn't come home, wouldn't answer my phone calls. And he would never give the dog back. And my daughter and I went there to get the dog. And he gave her a black eye. And
gave your dog a black eye?
No, my daughter, because we were there for my dog.
Did you call the police?
Yes. The police, he lied to the police and said we pushed our way in and assaulted him.
You did.
No, you can't respond.
He let my daughter in.
So here's the thing. If you're trying to prove a case, and this goes to both of you, I need the big W's. Who, where, what, when, and why. Okay?
Yes.
So you need to think about what you're telling me because I can't connect anything. All I know is that you got a dog, something about June 13th, and then he took your dog.
Oh, on August 24th, 2025, my son Ryan brought me a puppy because his dog had a litter of puppies. And I said I wanted one. So August 24th, he brought the dog over to Ted's house because that's where I was. And so he did.
Did you live with Ted?
Some back and forth. I was staying there, yes, for a while. But then when I would go back to my mom's, my dog would come with me. And the plan was for me to always go by my mom's because I have to help take care of her. She's 92 years old. And he knew that. But then he was mad because I was leaving with the dog. So he took the dog and wouldn't give him back.
So question, you would go stay with Ted, then you'd go to your mom's, then you would stay with Ted, then
Yeah.
you'd go to your mom's.
Yeah.
When you went to your mom's, was it just to take care of her? Or did you have a fight with Ted?
Yeah, when he'd get on my nerves, I'd go to my mom's.
How often did that happen?
Couple times.
Between August 24th, 2025, and when you moved out June 13th?
Yes.
2 times?
Yeah, between them. Yeah, between them dates.
Not really to take care of your mom, just because you had fights with Ted and you needed a break.
Well, they were building me a room over there. So I have a room and I wanted to go back there, but he didn't want me to. But I was going there during the day and helping her. And I mean, she does have a husband. I'm just there to help a little, not totally take care of her.
So when you went over to help her a little, to take care of her sometimes during the day, did you bring the dog?
Yes.
The dog always go with you places?
Yes. Not always. I went to Alabama for a week and Ted wanted to keep my dog. He talked me into leaving my dog with him, so I did for a week. That was in February.
Who'd you go to Alabama with?
My son, Keith, we went to visit my brother.
Okay. And as of June 13th, 2026, this year, you ended the relationship with Ted?
Yes, we were just friends. We were just friends. I was just staying there as friends.
So nothing romantic,
No. Never kissed, never did nothing.
totally friends, okay.
Mhm.
You had your own room?
No. We slept on a fold-out couch in the living room
Okay.
together, but we never were together.
Who took the dog to the vet?
We both did.
Who paid for the bill
I did.
every time?
Yes. And he has a dog, Pete, and I have Max. And we took the dogs together every time. And they tried to put the bill together. And I said, no, I'm paying for my dog and he's paying for his dog.
Who bought the dog food?
I did. Well, he bought the dog food. I bought all the treats. My dog didn't like dog food. He didn't eat much dog food. He was just a little puppy. I bought all the treats, and that was a lot more money than the dog food.
What kind of dog is it?
What kind? Pomeranian.
What else can you tell me that proves that you own the dog?
I have text messages from August when Ryan and we were talking about me getting a puppy. And I have what I named him and the day he brought him over.
That's between you and your son,
Yes.
not between you and Mr. Hunter.
No.
Okay. You can bring those out when your son testifies, but not right now when Mr.
Okay.
When you're just telling me your story, your testimony, okay?
Yes.
All right, what else?
I have from the vet, because it was in Ted's name and I didn't know that both dogs it says he's the client, so I went in there and they gave me with my name on it, like July 2nd, when I knew I had to go to court. Because he had this plan, he was gonna steal my dog.
Okay, what else?
Let's see, what else?
Do you have proof that you paid the vet bills?
I paid cash. And I went there trying to get a letter. And she said, she gave me a copy of his vaccination and said that was good enough, that should be good enough. She wouldn't write me a letter.
Generally, when you go to a vet and you get services done, you can pay in cash or
Yeah.
whatever method they take, and they give you a receipt that says paid. Do you have any receipts?
Yes. They gave me copies of like when I paid.
And it says that Ms. Cleveland paid?
I gotta look. Yes. It has my name on it.
You asking that I take a
No,
look
yes,
at that?
my name is on the
Are you trying to
paperwork.
use that as evidence?
Yes, but they changed it from his name to my name because it's my dog. But originally, his name was on for both dogs. Pete is his dog and Max is my dog.
Okay, I understand that. I was asking, usually when you bring a dog to a vet, it says somebody paid.
They never gave no receipts.
What vet do you go to?
The wellness center,
I can tell you that's not true.
well then, maybe they did and I just lost them, but they gave me copies of all that when I went in there.
All right. Is there anything you want me to see? Do you have evidence?
Yes, I have the vaccination certificate and the text messages. And, that's it. That's it.
Do you have questions for her? Just questions, not statements.
Not right now, no.
Okay. Are you gonna ask to call your son to
Yes.
provide testimony?
Yes.
Please come forward, raise your right hand. You're gonna be sworn in. Come and have a seat at the witness stand.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Over there.
Once you are seated, please state your name and spell it for the record.
Ryan Cleveland, RyanCleveland.
All right, now you may ask him questions, Ms. Cleveland.
Who did you give the dog to?
I gave you the dog, Tammy.
Mm,
Who, where, what, when, why?
When did you give me the dog?
They would have been, they were born on June 28th. So it was August, middle of August, sometime. I brought you the dog.
And I text you, what did I name the dog?
You texted me and let me know that after I'd given you the dog, you thought about it and you ended up naming the dog Max.
I don't know what else to ask. I don't know what else to ask.
Did she have to pay you anything for the dog?
No, she didn't have to pay me for the dog.
Are you a breeder?
No, No, our dog had puppies, and my mom's dog that she'd had before this had passed away, and I knew she was wanting a puppy, and it just so happened that I had them puppies, so I gave one of those dogs to my mom because I just knew she wanted a puppy, so.
Purebred Pomeranian?
Yes, ma'am.
Did you intentionally breed your dog?
No, we ended up, I got two Pomeranians at two separate times, I guess, and the one ended up, we weren't able to stop the one from getting pregnant, so we ended up having a litter of puppies, not on purpose, but it happened, so.
Don't Pomeranians usually need to go to a vet to birth their litter?
I mean, we birthed them at home. I mean, I don't believe they go to the vet to get birthed.
Okay. How many puppies were born of the litter?
There was 4.
Ryan,
Nope. Oh, well, do you have a question for him?
yeah.
Okay.
The first litter, how many puppies?
The first litter,
Don't remember.
I'm trying to remember.
I have one of them and you have,
I still have one of or I got 2 puppies, so the first litter there was 3 or 4, I guess. I know I have 2 of them. I gave my mother one of them, and I think we had sold one to somebody, but I think 4 is what she had.
Okay.
I thought it was 3. 'Cause-
Oh, it doesn't really matter.
Yeah,
Yeah.
3 males.
So any other questions?
Mm. No.
Mr. Hunter, questions for Mr. Cleveland? You may step down. Thank you.
Thank you, Your Honor.
Any other witnesses, Ms. Cleveland?
Just my daughter that tried to get my dog for me, but I don't know if that matters.
Is your daughter here?
Yes.
Well, I don't necessarily know if you need her to provide testimony, but I'd like to hear from Mr. Hunter. Mr. Hunter, you've heard the testimony of Ms. Cleveland and her son Ryan, who was the owner of all of the dogs, and you've heard their testimony. What would you like the court to be aware of? Why do you think this is your dog?
Well, I got a dog from my daughter, and he was used to playing with other dogs, you know. And so I wanted to get another dog for him play with, and her son had something that he was tired of taking care of, I guess, and I said I'd take one, you know. She said she wasn't really sure she wanted one, and I said, no, I want one, tell him to bring it over. You know, I needed shots. I said, I'll get the shots for it. So we brought it over and dropped it off. And
Okay. You have any proof that he gave you the dog?
he just brought it to our house. She was staying with me.
But other than that, nothing else?
Well, I just from the vet and the dog license.
I have text messages because Ryan told me he couldn't afford to get the shots. And I said, I will pay for the shots. And I have that on the text.
Okay, that's fine. Unfortunately, I have to look at the evidence here, Mr. Hunter. She was living at your house, but not really living at your house. She had
Well,
the
she was
dog.
living there.
She took the dog. She brought the dog with her to her mom's. Her son gave her the dog. It was from her son's litter. you say that you have proof that she's lying, maybe about when you got the dog, and she said the same thing, that he dropped the
and
dog
what-
off at your house. when
She
was
said she
there.
wasn't living at my house when she said she got the dog before, in her first statement that I got from the court records there. That she wasn't staying at my house. She moved in after she got the dog.
It doesn't matter when, where, what, or how, or why, except for the fact that it's all been stated that the son had the dog because it was one of,
I got a concern though, that she has a really bad opioid problem,
yeah,
and I'm
a
just,
lot of pet owners.
and I'm afraid the dog, if she would drop one on the floor, the dog's gonna eat it.
Yeah, that would be unfortunate, but unfortunately for you, she owns the dog. So you have to give the dog back. Okay? So I can't control what she does in the privacy of her own home unless it affects the community. And the fact that you have a concern, perhaps that you think she has an issue,
I know she does. She lived with me 9 months.
but that doesn't come into ownership of a dog. So you are in possession of the dog?
Yeah.
Today is Monday. Wednesday by 4, turn the dog over.
Okay.
Thank you.
Can you go retrieve the dog with you and Ryan? Go get the dog Wednesday by 4. That gives you a little time to say goodbye to Max. Okay?
Thank you.
All right, anything further?
No, thank you.
All right, then we are adjourned, except for, I'm gonna say, you have to make sure you turn over the dog and you be nice about turning over the dog. Nothing happens to the dog, or you can be held in contempt with fines, fees, jail. Okay?
What about costs? Are we doing that or not?
Oh, costs,
Court costs.
court costs. Each are gonna split the costs,
Okay.
because it seems like they didn't have a very defined relationship or cohabitation agreement, so.
Okay.
Court costs and fees are split, so you have to reimburse her half of the court costs to file the complaint.
What happens when a defendant begs for one last chance, but the judge refuses to accept excuses? This courtroom hearing delivered exactly that. One of the most emotional moments came when Matthew Castro stood before the judge asking for probation instead of prison. His attorney presented witnesses who described him as a hard-working employee, a loving son, and someone with a job waiting for him if he were given another opportunity. His employer even testified that Castro had been one of his best workers and wanted him back on the job. His mother spoke through tears about the difficult events their family had endured, including the devastating shooting of Castro's brother, and how she believed her son had finally matured and was ready to rebuild his life. Then